All right, and we will now move to the next session, the legal pitfalls that doom a startup. It is going to be conducted by three people from the global law firm of Morgan Lewis. So Morgan Lewis is recognized in the areas of exceptional client service, legal innovation, and commitment to its communities. The firm's global depth reaches across North America, Asia, Europe, and the Middle East, with the collaboration of more than 2,200 lawyers and specialists who provide elite legal services across industry sectors for multinational corporations to startups around the world. We are fortunate today for this session to have three of the partners from Morgan Lewis who will be speaking to us. First will be John Park. He works with the corporate business transactions and finance practices. He helps VCs and CVC clients structure and implement early and late stage investments. He also represents private and public companies, providing general corporate and strategic advice on financings, partnerships, joint ventures, and M&A transactions, as well as inbound, outbound, and cross-border transactions. And also, John is the secretary for the XTC not-for-profit organization, and Morgan Lewis also provides legal support to the XTC. Joining John will be Karen Abesamis. Karen is also a partner at Morgan Lewis and a founding member of the Women in Tech Initiative. Having practiced in the Bay Area for more than a decade, Karen has significant experience working with technology companies and non-technology companies that are finding opportunities to grow through the use of technology. And last but not least, we also have Rahul Kapoor, who will join, and he is the local practice group leader of the Silicon Valley and San Francisco corporate and business transactions practice. As a member of the firm's advisory board, leader of the India Initiative, and co-leader of the Technology Initiative. He previously served as the firm-wide hiring partner and on the firm's diversity committee. Thank you all for being here from Morgan Lewis, and I will now hand over to you, John, and the team.
It's great to be a part of XTC. As a firm, we fully support XTC's broader mission to support the UN Sustainable Development Goals, and we're just so happy to be part of this boot camp. So I will lead with the agenda and then be joined by Karen and Rahul. So to set the stage, what we're going to cover in this roughly 1 hour session is the incorporation process for startups and the legal pitfalls that we see, with a particular focus on a cross-border startup with questions related to hiring and retaining talent across borders, IP issues as it relates to protecting the technology of the company, and then also cover some initial steps to an exit with an M&A transaction. So without further ado, I'll go ahead and start. So with respect to the incorporation process, one of the key elements of this process and a pitfall we typically would see is the incorporation of the company and the timing of when you actually form the company. And I know many of the companies that are part of the bootcamp have already incorporated, but this might be a review for many people, but it's always good to kind of think about when you start a company, how you do that. And also we'll cover hiring and retaining people, which will be relevant for startups that are already incorporated in terms of building out the founding team. So in terms of the timing of the incorporation, there are various pathways to actually founding a company. Many people will start a company out of grad school. Many will come from another company. Many will be with another startup. Many will be with a large company. And so those different pathways need to be thought about in terms of when you actually decide to incorporate and where. So for example, if you are working at a large tech company in Silicon Valley or London or Beijing, initial question is, at what point do you exit that company? And at what point do you actually incorporate the new company? And generally, one pitfall, the first pitfall we often will see is that some people will actually get together and form a company while they're employed by another company. And that generally is not a great idea, because you generally have a duty of loyalty to your current employer. And to the extent you're using company resources or time to set up the new company, that's often the first pitfall we see when we meet with a company. So one thing to think about in terms of the timing of your incorporation is having a cooling off period between when you leave your former company and you start the new company. So that's just one example of something to think about. Timing the sequence of events before you actually start the company, and can you create a window of time between the events so that there's less of an issue with respect to any IP or residual rights that your former company may have to, the IP you're developing at the new company, for example. Similarly, often we'll see teams of people that will say, hey, we should leave this company and start a new company. And one thing to think about in that situation is, and another pitfall we often see is, one person will leave and they will announce their departure. The company's fine with it. There'll be a period of time before they set up the new company, maybe 3 or 4 months. And then they decide, I want to actually bring or build out the team and hire a few people from the company where I was employed. The issue there is often there are non-solicit provisions in your employment agreements with your existing company. So you need to review those documents to confirm what are your obligations in terms of restrictions on your ability to recruit people from the company that you left from. So those are some specific examples about the timing and how you want to think broadly about all the people you will need to start the company and how are they going to cleanly exit or depart from whatever institution or company they're starting from, and how do you time that in a way to reduce the risk of any potential claims from any of those companies or institutions. So that's really important, is the timing and the sequencing, the building of the team in a way that protects the new company from potential claims. And now I'm moving to the entity structure and jurisdiction questions. So the other pitfall we often will see is that the company will incorporate, and there are many different types of entities, S corps, LLCs, C corps, and then there's a choice of where you're going to domicile, whether it's Delaware, Cayman, or other overseas jurisdiction. So I think it's important to think about where the business will reside, where your customers will be, where your investors reside, and where your revenue will be booked. And if you look at all that and map out those various jurisdictions, you'll determine whether it's more US-centric, maybe it's more Asia-centric, maybe it's more of a business for Europe. After you look at that, then you can think about the appropriate jurisdiction and choice of entity, and then determine what is the best process. Now, various structures have different costs. So many people will think about doing a holding company structure with sub-entities and all the areas of where the business will operate. So those are all things to think about, but there's often substantial costs in setting up those structures. So it's important, I think, and this is another pitfall, to map out where you think the business will grow, but there's only so much you can do. And I think a lot of times people will try to overinvest in this before they even know where the business is evolving. And to be frank, 9 out of 10 funded startups are Delaware C Corps. So if you just want to go with what's the middle of the fairway approach, Delaware C Corp, 9 out of 10, even 99% of the startups are Delaware C Corps. And there's a reason for that. And the reason for that is that Delaware makes it very easy for you to incorporate. Most of the VC investors are very familiar with the Delaware corporate structure, so it's a very less of a constraint for your investor base. And also, if your exit is going to be a U.S. buyer, for example, typically, it's going to most exits could be a U.S. buyer. Having a U.S. entity is going to be very easy to sell in terms of due diligence and the ease of completing a deal. So there are many reasons why you may want to stick with a Delaware C Corp. The fourth item is the charter, the bylaws, and the organizational documents. So once you meet with your counsel and you determine, this is where we want to go, we want to just do a Delaware C Corp, they'll provide a certificate of incorporation, the bylaws, and the initial organizational meeting minutes of the company. And these documents take a few days to prepare once you've decided that you're going to do a Delaware Corp. And the certificate of incorporation basically authorizes the common shares that are issued to the founders, and eventually will be amended when you issue preferred shares to your investors. So those documents are fairly basic. I do think it's important for founders to review those documents. Often they kind of get shuffled away in an email file, but be sure to review those, especially the bylaws, to make sure that you understand what the corporate governance requirements of the company are, just as a matter of duty of care, to review those documents. And as I said, there'll be in those documents provisions as to the board of directors, the officers' responsibilities, and the governance of the company. Typically, there'll be, when you first incorporate the company, you'll determine who the CEO or the president will be, and the director positions as well. Now, a lot of startups will incorporate and have questions about, how many board members are we going to have? Typically, once you're financed, it's going to be 5 board members, but we often see startups that will have advisors as well. And that's another good practice, is to have more people as advisors initially rather than board members. You can fill out your board later. So that's something we see. And in fact, we have a lot of companies that incorporate with just one person, because one person can serve as the president, secretary, and the sole board member, at least initially. And sometimes what we will see is sometimes founders will spend a lot of time trying to build out the board, thinking they have to have all these positions filled. But if you're just trying to incorporate initially, you can incorporate and then add those positions later. And as part of that process, you'll be issuing equity and options to the founding team and the board members. With respect to the equity issuance, we'll cover this in a later slide, but there's a timing issue there as well with respect to 409A. So I think 409A probably, if you were to think about what are the legal pitfalls of incorporating a company, the largest category of pitfalls relate to 409A. So I'll just spend a few moments on 409A. So 409A is an IRS provision that came into play several years ago in response to option backdating practices that had been become an issue in Silicon Valley. And basically what happened was companies were picking dates for option grants with the most favorable pricing to allow their employees to have lower pricing. So if the employee was hired, they would quote unquote backdate that option grant to when the price was lower to give the employee the benefit of that lower strike price. That practice came under a lot of scrutiny, and as a result, 409A came into being. And basically what 409A provides is that it is, if you issue an option grant, and it only applies to option grants, at a price that's below the fair market value, 409A imposes severe excise tax on the holder of that option if it's a below market grant. So the takeaway is that you want to make sure that when you price option grants as a founder and as a board, that you have a methodical and rational approach to the pricing of those stock grants. And most of the companies we see, in particular the startups, get caught up or basically make the mistake of issuing options at a price below the fair market value without getting a valid 409A valuation report. So that's probably the biggest mistake we see generally. And I think the other takeaway with respect to option pricing in terms of when you start the company is that you want to make sure that you actually incorporate and start the company early enough so that you can issue those first initial options at a penny or at a very low price. And the only way you can do that is if you incorporate very early in the process. And so what will often happen is we'll meet with the founder and he'll say, oh yeah, so I started the company about 2 or 3 years ago. Now I'm coming to you because I'm ready to paper the company. The problem there is that if you wait to paper the company and incorporate 2 years after you've started the business, then the values are already very high and you can't really justify an issuance of an option grant at a penny, for example. So that goes back to the initial timing issue that I mentioned. You think about what is the sequence of events. How can I make sure to document and paper my option grants early enough so that we qualify the grants as as actually being a fair market value. And often we'll see companies that will wait till, for example, till when they get the term sheet signed, because they think, okay, well, we don't want to, spend time setting the company up. Once we get the term sheet, we'll worry about it. That is a hard thing to do, because if once you get the term sheet, that's an indicator of value in the company. So it's going to be hard for you to say, oh, we got the term sheet and we incorporated the next week. The values are already there. So it's all in the timing. It really is. And being prepared is the key to having a clean setup for your company. And once you do that, you'll be so much better off, because you won't have to redo all this. The worst thing that happens is you don't do it correctly the first time, and then we have to actually dissolve the company and start another company, because it's harder to clean up a mess than it is to just shut it down and start it over again. So you want to avoid that pitfall. And so that's why it's so important to seek out counsel, one, and two, make sure you're ahead of the game and making sure you incorporate before you do too much in terms of setting the company up, setting the business up, or accumulating any IP. So now moving into the details of actually some of the issues we also see in terms of your exit from the former company. So it's really important that as you look at starting the company, and this also applies to an existing startup that is hiring a new CTO, for example. So either you're setting the company up or you're building out your team. In this scenario, the first thing to think about is, what are the obligations of the person you're trying to hire vis-a-vis their existing company? So make sure that you review their agreements, their employment agreement. There may be a non-compete agreement they may have signed in connection with a prior sale of their company. So you want to review all those requirements. Often, for example, a non-compete could have a 12 to 3 year time horizon. So if you're in the first year, you want to make sure that the guy you're trying to hire is not subject to this non-compete for 2 more years, especially if the definition of the scope of that non-compete applies to the business you're starting. You also want to consider immigration and sponsorship issues. And this is also very critical for a cross-border startup, because you may be hiring people in different jurisdictions, or people here in the US that are on H-1B visas. So make sure that you think about, well, if this person's going to leave from this company, are we really ready to sponsor that person with an H-1B? How long would that take us? Because you don't want the person to be not working under a valid visa permit. And generally, the range is 30 to 60 days, where if you exit a company, that there may be some time where you may continue to work, but there's a cutoff, and you should look at that and talk to your immigration counsel, of course. The other key thing is, of course, when you leave the company, you don't want to take any company property, obviously. But again, get a little more complicated, because people will use their laptop. They may have data files or other work product, right, that conceivably was done on their own time, maybe on their their home, their laptop at home. But are those files still residing on your hard drive? So check those things. Make sure that you've kind of done an inventory and purged any work files, any files that could be related to the work product you developed for your prior company or institution. Key to do that, because in some cases, and this is the pitfall, even though you may have done your best to have a clean exit, maybe you even told your employer that you're doing this, and everyone said, hey, that's great. We don't, best of luck, good luck. Then your company becomes a big success. Then you may get a letter from that company or institution saying, oh, we didn't realize that before you started this amazing company that some of those ideas may have come from what we were doing when we worked with you. So if that were to happen, the most typical claim is what is called a misappropriation of trade secrets claim. And you want to avoid that. And the way you avoid that is to make sure you're squeaky clean in terms of any data, files, or work product that you may have kept from the prior institution or company. And the last point here is, be sure to review the university policies and procedures, especially if you're onboarding someone who was a grad student at Stanford or Berkeley or Caltech. Make sure that there's nothing, any IP that they may have assigned to that university, or maybe there was a procedure with respect to any co-developed work while they were at the university in terms of the lab policy of that university. There may not be an issue, but you want to be familiar with those documents to make sure that you're complying with any continuing obligations that may that may be in effect. So now we're going to segue into the IP issues when you're starting a startup, and I'm going to hand it over to my colleague, Rahul.
Thanks a lot, John. Thank you, everyone, for having us here today. And first of all, congratulations to all of you for being associated with XTC. I will be talking today about 6 pitfalls that are IP, intellectual property related, that you should all be careful of and that could doom a startup. The first one is fairly straightforward, and it's about protecting the confidentiality of your IP. And think of that from 2 perspectives. One, your IP itself, your crown jewels, clearly you want to protect them. Once you've decided on an appropriate IP strategy of how you intend to monetize or protect your products with your IP, if indeed you're going to try for patent protection, then you should probably file a provisional patent application before you disclose any of your IP to anyone. And definitely always try to have some form of an NDA or confidentiality agreement before you do that. No disclosures in trade shows, publications, websites before you take that step. The other aspect of that is to think of the confidentiality of third parties that you may have. I caught the last bit of the presentation by Lars from NXP, and he ended with talking about a lot of data that they were collecting through their software initiatives. When you have confidential information of third parties, it's important to make sure you protect that as well as if it was your own, to avoid potential disputes and litigation with third parties if some of that gets inadvertently disclosed. You could obviously lose your trade secrets in your confidential information if it's disclosed without an NDA in place. And you will diminish, at least in the US, your patent rights, your ability to get patent protection. And in most of the rest of the world, you would lose that if you disclose your inventions before you actually file a provisional application. In each of these cases, consider this on a case-by-case basis. But this first point is something that most people are typically well aware of. The second pitfall is failure to establish clear IP ownership. And my first point here, and this is one that surprises people at times, is payment does not equal ownership. So let's presume a hypothetical where you hire a consultant to develop some software for you. You have a handshake agreement. The person develops the software, turns it over, you test it out, it looks good, you accept it, you make the payment. The presumption would be you own that software, and that's not the case. In order for you to actually own that software, that work product, you need a contract with that consultant, with that developer, and you need an affirmative assignment of that IP to you, to the company. Absent that, the best you could argue for would be an implied license to use what you paid for. So keep that in mind. Clearly here I'm talking about consultants, not employees. With employees, you'll have your employment agreement that would cover these issues. Be careful to establish ownership of the entity, the corporate entity, the company that's created pre-incorporation. So any IP that any of the co-founders create or when any of your early employees create, pre-incorporation needs to come into the company. And to add on to the point that John made earlier, sometimes people start their companies while they're still employed somewhere else. And in that case, make sure you have an adequate separation of how that IP was created, and this being the IP that you're going to use to jumpstart your new company, your startup. And then the last point on establishing IP is joint development. A lot of times you may be working with and collaborating with others to jointly create some new IP. In that scenario, it's important to make sure that there's a clear understanding of the background IP, the foreground IP, derivative IP, and any IP that's created during that collaboration to make sure that the parties are clear on what use people can make of that going forward. The third point is failure to identify third-party rights. This can take on a variety of forms. The first bullet I'm going to talk about is open source software. There's still two views on open source, but most people generally agree that there's a lot of benefits that a company, especially a startup company with limited resources, will have on open source software. It clearly will jumpstart your development process. It's a lot easier to take some modules of software that have already been created by somebody and incorporate them into your product than to start from scratch and recreating that. You have a team. If it's an active open source project, you have a team of people out there who will help you fix bugs. On the other hand, you need to be careful of the type of open source software you incorporate and combine with your proprietary software. It's perfectly fine to use permissive open source software like the software available under a BSD or MIT license. On the other hand, you need to be very careful before using software available under the GPL or the general public license, which tends to be viral in nature, and if used and incorporated inappropriately, could taint and diminish the value of your proprietary software, which you may need to then disclose publicly to any comers. FTO, freedom to operate. In certain instances, you may want to get a freedom to operate for your particular product or process to make sure you are aware of what third-party rights there are out there that you potentially would be infringing or may need a license to before you actually get to market and start selling. And then in the case of trademarks, you want to make sure that you get a clearance up front if indeed having a strong brand or a mark is a truly critical part of your business, and make sure you identify and select a fairly distinctive mark as opposed to something that's either generic or that a third party has rights to. The fourth point is the pitfall of having poorly drafted IP agreements. And the first point here is, it's probably, in most cases, a mistake not to have an agreement. This resonates with the earlier point I made about payment doesn't mean ownership with the consultants. You don't have an agreement, you don't have an assignment, you may be in trouble. And so, these agreements don't all need to be long and complicated. You can have short agreements that are very clear on what each party's rights and roles are. Be aware of restrictive covenants that show up in unexpected sections. And as an example, most people will enter into and sign NDAs and confidentiality agreements, which for the most part tend to be fairly standard. There are very express provisions that one would expect in there. I can tell you from practice that I have run into situations where I'm looking at an NDA, and in one of the sections on, say, assignment or severability, you have a sentence that is essentially a non-compete or a non-solicit. Should not be there, completely unexpected. And so I guess my point is that no matter what the contract is, it is something you're binding your company to. So somebody at the company should make sure that there is nothing unexpected that shows up. It is indeed rare, but there are those bad actors out there, and you want to be sure that you don't fall into that trap. In these agreements, be aware of provisions like residuals, non-competes that may show up. This is an expansion of my earlier point. And you need to make sure that you understand and are knowledgeable about what you're agreeing to. John talked earlier about non-compete, so I'll skip that. Residual rights are rights that somebody gets to enable them to use information that they have in their unaided memory for the next project they may work on for a different company. It's part of trade secret law, and that varies from state to state. So certain states, like say California, is very pro-employee. So the state, through its rules and policies, encourages people to easily move from company to company, which is arguably one of the reasons why the state of California and Silicon Valley in particular has been very successful for startup companies popping up all the time. The last point there, that exclusive P actually stands for exclusive patents. Keep in mind that different forms of IP, patents, copyrights, trade secrets, trademarks work differently. If I was to give an exclusive patent license to Rajiv, what that literally means is that that license is exclusive even as to me. So I couldn't practice my own patent if I gave an exclusive patent license. And so I would need to retain that right. And one needs to be aware of those tricky points in IP law in your IP agreements. And then the last point on this is, many of you on your websites will have privacy policies. Given the additional focus on privacy issues these days, all around the world, in California, CCPA, obviously EU has a huge privacy and data policy regime. Make sure your privacy policies are accurate. The worst thing you can do is put something up there that's either inaccurate or misleading. The fifth point on pitfalls, IP pitfalls, is a failure to create a fully thought out IP strategy. Sometimes early on as a startup, it may seem that it's not critical. I think it's important at least to spend some time as a company to decide how you intend to protect your IP, what your business strategy is, and how that interacts with your IP strategy. So for example, are you going to try and protect your technology by patent law or trade secrets? And it'll vary depending on who you are as a company, what your products are, and how you expect to monetize your products. You want to make sure your IP strategy covers downstream products, how you protect and sell them to OEMs or your customers, and that the IP rights flow through and all the licenses can flow through. The third point on this is to think about pass-through of risk. And what I mean here is, as a company, you may have suppliers who are licensors who license or supply you products, which you then incorporate into your products downstream. Make sure you're not taking on risks from your customers in terms of indemnification or limitation of liability that you can't pass through to your suppliers. You don't want to be caught in the middle as part of your IP strategy. And then it's always good to have an inventions committee that encourages your employees to capture their inventions, their disclosures, that then the inventions committee decides they will protect through patent law or trade secrets or other forms of protection. My last point on IP pitfalls is dealing with standards organizations and competitors in these SSOs. Many of you may find that it is helpful for your company and indeed for the market that you work in to join some organization, a standards organization, to collaborate with competitors and come up with new specifications to set standards. There's been huge successes around the world in this area. If you do indeed do that, make sure you understand what the disclosure obligations are that are placed on you as a member of the organization, and also what obligations you're signing up to in terms of licensing of your technology and IP to the other members and the market at large. You need to be careful whether they're royalty-free obligations that attach to your patents or whether they are indeed RAND, which stands for reasonable and non-discriminatory licensing. This is no different. Signing up to a standards organization is no different than signing a contract with somebody. And so you need to be careful about those obligations when you join such an organization. So these were the six that came to mind for this presentation. Obviously, there's lots of other things one could talk about, but these are the initial six pitfalls that I think are particularly important for startups.
Rahul, I noticed that there's actually a question in the group chat related to IP, so perhaps we can pause and answer this question. The question is, when licensing biotechnology, is a strong agreement or contract sufficient to protect underlying technology when a patent is not yet filed?
The answer would be yes. I mean, I think any contract you have can be strong enough and have strong confidentiality sections and disclosure obligations in that contract to protect it. For most biotechnology companies, whether you're talking about a true biotech or a large pharma, in those contracts, there are typically very long provisions around disclosure or publication of the innovation that's going to happen between those parties. And there's long sections that typically lay out the process of notices back and forth, giving opportunity to one or both parties to file for patent protection before there's any publication or the release generally to the public. There are also sections that talk about protections between the two parties. And in many of those cases, typically the larger entity is doing similar deals with other startups. So if you indeed are the startup, you need to be aware of what your obligations are and what the obligations are of the larger entity with respect to competitive actions between the parties.
And Rahul, there's another question before that too. And this is, if a company wants to scale geographically, how do they assess which countries to file the PCT in? Patents in, because there seems to be a trade-off between the cost of filing versus future protection and growth of the company globally.
Excellent question. And that obviously is a big challenge, especially for startups, but it becomes a challenge even for larger companies. I think, and so for the larger group, a PCT is an application you file in the EU, and it covers the EU in general. And then at some point of time after a period of 18 months, typically you can go national phase where you apply for patent protection in each country. And but to broaden that, you think of filing for patents around the world. At some point, you try to get patents in each country because you enforce patents by country. And that obviously has costs associated with it, not just to get the patents, but also to then maintain them over the 20 years or whatever time period is left of the patent term. The answer to the question is you have to sit down as part of your IP strategy and correlate that with the business strategy. And what I mean by that is you have to decide where is the market in terms of your revenue as a company. So so for larger companies, you decide that clearly the US is a big market, maybe England, Germany, Japan, China, India, Brazil, and you focus your patents, and this is true even for trademarks, but you focus on those countries. And it's a trade-off. If a country is not going to be if it's just 0.5% of your overall revenue, maybe you pull back on patent protection there, or at least pull back on the number of patents you would try and get there. Maybe you have, let's say, 80 patents as a company. Maybe you take some of your strongest patents and only, push on those for countries that form a smaller part of your revenue stream.
Rahul, there's another question. I think it may be a good time to ask this one too from Joy. Can you speak about pitfalls or watchouts in changing corporate structure so all IP is held by one entity and licensed to the subs? The objective is to make it easier to monetize or exit additional market segments while we retain rights to our core market segment.
Excellent question. I'll make 2 points here. One, I actually taught an entire session on that. I used to teach IP for a long time, and it's a great point. I'll try and answer it in short. Then I do want to give my colleague Karen an opportunity to make sure we complete our presentation. I'd be happy to talk to anybody online if needed. But here's the answer. From the perspective of the company that's trying to do this setup where you have all of your IP in a holding company, which then licenses the operating company, what that does is, from this company's perspective, that separate holding company with the IP can then go after others in the market to offer licenses that maybe the operating company would feel restricted to do because of commercial reasons. That's one perspective of it. On the other hand, from the licensee's perspective, as long as they see that connection, they're going to, even if it's the holding company reaching out to them, they're going to try and assert some of their IP against the operating company. What some companies have done to try and avoid that is to form collaborations with, say, 2 or 3 other companies, so that the holding company, if you will, of the IP is not controlled by any of the 3 or 4 operating companies. So there is a separate distinction there. But many companies do have a separate holding company for IP rights, also for other reasons, like tax reasons. And so you can take all of your IP and put it in a more tax favorable state or country for the IP, so that when the IP is then licensed or enforced, the revenues coming there have different tax consequences than what the operating company would have, say, in California. Thank you for your questions. I'm happy to answer others. It may be a good time to move to the next slide.
So next slide is on founder employees. I'll cover this really quickly, and I've already touched upon this already, but three pitfalls on this slide is that in terms of the equity allocations, try to keep the team manageable. A lot of companies will incorporate and say, we're going to issue 20 option grants right out of the gate. Try to do it in stages, because although you do have the protection of vesting schedules, often the team is going to evolve. So make sure that you do it incrementally in terms of building out the team. Also consider, for a global startup, the different interests of employees in different jurisdictions. Developers in Asia or Europe may favor more cash comp rather than equity comp that we typically grant in Silicon Valley. In terms of vesting schedules, try to be reasonable in terms of vesting schedules. And if you are really early stage and you haven't received any financing yet, go ahead and put in a market schedule. That way, when the VC comes in, they're not going to repaper your vesting schedule. So try to preempt that discussion by going with a reasonable schedule. Now, the typical schedule is 4-year schedule with a 25% cliff on the first year. But if you do 3 years with a 1/3 vested after the first year, sometimes VCs will accept that. So try to go with a market schedule and not leave that discussion, because once the VC comes in, they're going to impose a standard 4-year schedule. Also consider local law labor requirements, especially for global startups. Many of the IP statutes in other jurisdictions require some form of reasonable cash remuneration. So just using your standard Silicon Valley documents will not work in India or South Korea or Japan, for example. And also consulting arrangements. A lot of companies think, oh, we just hire the consultant in this geography, then we don't have to actually qualify to do business. That may or may not be the case. So be sure to check with your attorneys on that. Next slide is on financing alternatives. I'll quickly cover this. I think the takeaway here is that there are many ways to raise money to fund a startup. Think about the longer term relationships that you're going to be developing through financing your company. Really do research and due diligence on your investors, because this is a long-term relationship. And a lot of startups, the main pitfall is they get in an angel and they regret it for the rest of the company, because it's someone they couldn't work with. They don't even know the business or the industry, and there ends up being a bad outcome. So definitely think carefully about who you take funds from, and also in terms of pitching companies. The other pitfall is people tend to overpromise and underdeliver. You definitely want to underpromise and overdeliver in terms of managing the expectations of your investors, which is key to having a good working relationship with your investor base. So with that, I'm going to turn it over to Karen to cover M&A exit.
Thanks, John. Greetings, everyone. Thank you for allowing us to present. It's our pleasure. So we're ending on the topic of M&A because no matter where a startup is in its life cycle, an exit tends to always be in the back of your mind. So the key takeaway from my presentation is really that there are steps that you can take now to ensure a smooth and successful exit, no matter where you are in your life cycle. Further, there may be some of you who find yourself in a position to be the acquirer, to acquire another company. So we wanted to give you some things to think about there. First, it's important to understand that there are different acquisition structures. So when people say M&A, it's a broad term, but there are 3 different transaction structures that could take place. The first is a merger, and that's where 2 separate legal entities are becoming one surviving entity. This is the most typical structure used, and in particular, the reverse triangular merger. And the reason for that is that the company at issue remains in existence, and you do not need to get third-party consents or assignments for various key agreements, in particular, your IP and technology. There's a lot of caveats around that, depending on what the actual language of the agreement says regarding assignment, but in general, that is the principle for why most people go with a merger transaction. A stock sale is when a buyer is purchasing the shares directly from the stockholder. So again, the company at issue remains a separate entity, and sellers like this because the entire company is being acquired. The downside here, and the reason it's less often used, is because you need to get 100% of the stockholders to approve. So if you have a small company, a closely held company, this is a great option for a structure. If you have many different stockholders as well as a number of option holders, most tend to go with the merger structure. Last is an asset deal, and this is where the buyer is buying certain enumerated assets. Buyers like this because they can avoid unwanted assets and unwanted liabilities, and they tend to get better tax treatment this way. The risk to the buyer, however, is they end up not buying everything that they want. For the most part, sellers tend not to like an asset deal. It is not as tax advantageous to them, and they are still left with a portion of the company. So if you are the seller, the bigger push will be towards a merger or stock purchase. If you are the acquirer and you're attempting to add to your existing startup, you may want to consider an asset acquisition. So within the definitive agreement, there are a couple of key components that I wanted to just flag. The first is what's called reps and warranties. So for many of you who have already sold shares or you have an investor base, the reps are fairly similar. In an M&A transaction, the reps are definitely going to be a lot more comprehensive, but at least you've gone through the exercise of giving these reps and warranties. Reps and warranties are really statements about the company, saying that you are in good standing, saying that this is a full list of your various contracts. Reps and warranties tied to indemnification, which I'll get to shortly. But the other thing that this ties to is your disclosure schedule. And the disclosure schedule lists out a lot of information about your company. And when we get to the next slide, I'll have a few key pointers there. The second key component of the definitive agreement is the conditions to closing. So these are M&A specific conditions to closing. So for example, your approvals. But the other item that can tend to be in the condition to closing is various actions that the buyer needs for the seller to take in order to get comfortable with the acquisition. So John and Rahul talked a lot about some of the pitfalls that startups find themselves in. If you do find yourself in one of those pitfalls, despite best efforts in an M&A transaction, there are often buyers who will require that these things be remedied before they take ownership of the company. So for example, making sure that all employees sign their IP invention assignment agreements, making sure that all option holders sign up to various agreements that have been entered into with the company related to the stock plan. The last key component is the indemnification provision, and this is the duty to hold harmless and compensate the buyer for any losses. This is most often tied to reps and warranties. So if any of your reps and warranties end up not being true, the buyer is able to make a claim to recover for damages. The other component of indemnification, again, to flag, is you can have specific indemnities that the buyer identifies as part of due diligence for things that they're not comfortable with during the startup's life, that they want some assurances on. John mentioned in his presentation making sure that when you break from your prior employer, that there's a gap of time, that you get all the requisite waivers. Oftentimes a specific indemnity will be that if a claim is made by your prior employer or a university, that the buyer would be indemnified and compensated should there be any losses there. So those three components are really key to understanding what you do now as a startup very much matters as you prepare to exit. So the key takeaway, don't wait. Even if an M&A is a long way out for you, there are steps that you can take now to make sure that in the event that that happens, you're in a great position. So the first is making sure you have complete and accurate corporate records. Oftentimes, as startups, you're busy trying to run the business, trying to grow revenue, get customers, get partners. But it's important to make sure that you are papering things, that you're signing documents, that you're having employees sign documents as well. Even if it ends up being that these get DocuSigned and thrown in your DocuSign folder, at least all those things are ready and available once somebody starts reviewing your records. The next is shareholder records, making sure that you have records from every single one of your shareholders. A very subtle tip here is it's always a good idea to have contact information for your shareholders that's not tied to the company email address. So for your investors, this is obviously a very easy thing, but often you have founders, option holders who then decide to exercise. A lot of time can elapse between when the company is formed and when there's an exit. So you want to make sure that you're able to get in touch with people no matter how much time has passed. For example, if you were to end up doing a stock sale, every single stockholder needs to approve. So you want to make sure that you have their contact information ready. Next is make sure you're assessing your governing documents now. And the most important thing I would flag here is consider who has approval and veto rights. There is a provision called a drag along that you want to make sure that you have in your documents, which says that if a certain percentage approves a deal, that everyone else will sign up to it. The last thing you want as you are nearing an exit is to have a deal that the majority of your stockholders think is great, but you can't get the last 5% to sign up to, and the buyer is not comfortable without that 5%. And even in a merger situation. So take a look at your governing documents now, consider whose vote you need and what you can do to make sure that the majority and management are able to move the votes forward in the event that they need to. The other thing to consider is make sure that you are aware what your obligations are in your governing documents. So to the extent that you are required to deliver information, such as financial statements or business plans at the end of the fiscal year, making sure that you are complying with any preemptive rights or the right of stockholders to be offered a right to participate in any future stock sale. Those are the kinds of things that are really important to making sure that you have clean records, and the ability to make those reps and warranties that I mentioned as to the health and cleanliness of your company. The next is capitalization records and option issuances. This is typically a fundamental representation, meaning that the survival period tends to be longer for indemnification. The cap, or the maximum amount you're liable for, can often be the entire purchase price in a deal. So making sure that equity is tracked very carefully. And I think most startups nowadays are using equity software such as Carta. Others, especially when you're really small, they tend to manage it themselves on Excel or have their law firm manage those records, which is fine as well. But the key is just to make sure that they are accurate and that they are kept up to date. The last point on things to not wait on and make sure you understand it is your founders and key employee vesting and acceleration provisions. So first is, as John already mentioned, make sure that there's a standard vesting in place now, so that when you do get to an exit or even another round of financing, that vesting isn't reimposed, to make sure that founders and key employees really have skin in the game still when pursuing on with the company. Acceleration will typically be honored by the buyer in the agreements. So if your documents currently say that in the event of a change of control, 100% of the shares will accelerate, buyers will typically agree to that. So make sure you have that in your documents now, as opposed to right before an M&A transaction. The last thing I wanted to cover is just process kickoff. So once you're in an NDA, once you're in an M&A situation, what are the initial things to consider? The first is a non-disclosure agreement. So for many of you in the business sense, oftentimes an NDA isn't always signed when you're considering talking to a business partner or a vendor or a customer, because you don't want to make it so formal. But in an M&A situation, it is highly encouraged that an NDA is put into place, because you are providing so much information about a startup that you have spent so much time and effort building. A couple small tips, and these tips can apply for NDAs that you enter into for strategic transactions, not just M&As. As the disclosing company, make sure that it doesn't require that you label every piece of information as confidential. That's burdensome to you. You run the risk that if you don't label something as confidential, that somehow an argument can be made that it doesn't require confidential treatment. So you want to just make sure that it's all information that you're disclosing to the potential buyer or to the potential third party for a transaction. The next is making sure your representatives are bound and information is only given to those with a need to know. You really want to narrow the scope of people who have access to your information. And then the last point on NDAs is just making sure that the definition of confidential information includes derivative materials. So if somebody were to generate a forecast based on the information that you provided to them, that also constitutes confidential information as well. Second item for process kickoff is presentation decks. And the key here is that when you are making these presentations, make sure that you're making it clear that these are projections and that these are not reps and warranties. Again, reps and warranties end up being tied to indemnification, and that ends up being tied to what you're on the hook for after the transaction. And so you certainly want to make sure you narrow that obligation. And the last point is engagement of advisors. And the key here is bring them in early. I had a deal where a company was trying to save money, and so they tried to fix a bunch of these small issues that didn't go so well during their company history, and it ended up causing a huge tax issue after the fact. And if you engage your advisors, you can really assess the most optimal way to remedy any issues that you may have come across, but also to package those as risks and then negotiate them as part of the definitive agreements through conditions to closing and the indemnification. So to the extent as startups, you may be a little concerned about paying your advisors, financial, legal, or otherwise, really making it clear that you need some limited assistance on a particular issue will actually go a long way towards saving you money and headache in the long run. So that's everything I have on M&A, and I think that's the end of our presentation.
Well, thank you so much. We had one question that came in, and so we'll hopefully you can cover it quickly. This is from KK, and they have an eco-friendly product, and his question is regarding standards like LCA, FDA, etc., which require lots of details about the product. How do you deal with disclosing information as the patent is still pending, but they want to be sure that they apply for these standards?
I'll take that. That's from Rahul here. So I think the key in terms of disclosure is that you get your application on file in the countries that are relevant to you. So once you actually have a patent pending, even though the patent hasn't issued yet and you don't actually have any enforceable rights in the patent, the disclosures that you've made in the patent application are protected as of the date when you filed it. So assuming that it is indeed deemed to be new, non-obvious, and helpful, and the patent actually issues, the disclosures in that patent application go back in time to the date you filed it. So once you file it, you can start disclosing that information, and it is protected. One thing to keep in mind is that the process obviously sometimes is very long and can be several years, and you're continuing to improve your technology and your product. So as you get those improvements over time, before you actually disclose those to any standards bodies, you will want to file either a new patent application or additional matter in terms of a continuation in part to the existing patent application to maintain protection for the new IP.
Sorry, very good. Thank you, Rahul. Well, that was fantastic. I think the amount of insights and information that the Morgan Lewis team was able to put together in 1 hour, it was a fantastic tutorial. So kudos to you, John, Rahul, and Karen for covering so much material. And I do hope that from an XTC perspective, our startups find that very valuable. Thank you again to Morgan Lewis for being a great partner and supporter for the XTC, and appreciate you all being here.